Good afternoon, everyone. This is John Sire, along with Anna Claire Sansoni from the Kitch firm. We're going to be talking about the latest alphabet soup to come along with Michigan's UPEPA, or Uniform Protection of Public Expression uh, Protection Act. We'll be going through kind of some of the history of it, the three-step analytical process, some of the procedures that are introduced, and try and give an overview with some examples about how other jurisdictions, because Michigan is one of several that has adopted this act in particular, as well as similar acts. So I will turn it over to Anna Claire to take us into the act and why we're here.
Thank you, John, and good afternoon, everybody. So why UPEPA matters now. In December of 2025, Michigan enacted the Uniform Public Expression Protection Act, or UPEPA, a comprehensive anti-SLAPP statute which became effective on March 24th of 2026. The act creates a special motion for expedited relief for civil claims, specifically targeting public expression through discovery stays, mandatory timelines, appeals, and fee shifting. It's designed to change both the economics and timing of claims based on speech, petitioning, press, or association activity on matters of public concern. So SLAPP stands for Strategic Lawsuit Against Public Participation. SLAPP suits are used to punish or silence a defendant for exercising their First Amendment rights by making it so expensive, stressful, and time-consuming that they just give up. It's also a communication to those watching that it's just not worth the risk. The result is a chilling effect on speech. Anti-SLAPP legislation exists to mitigate that chilling effect by giving a defendant an early way to get rid of a meritless claim before the cost of discovery and prolonged litigation. Before UPEPA was drafted by the Uniform Law Commission, anti-SLAPP law was a patchwork. States had wildly different statutes. Some were broad, some narrow, some states didn't have any at all. The inconsistency led to several problems, such as forum shopping, resulting in the drafting and approval of UPEPA in fall of 2020.
Okay, and before we had UPEPA, we didn't really have any formal procedure or process for addressing these types of claims. And one of the, I guess, guiding lights or examples was the JJ Construction versus Bricklayers case, where it was a contractor who bid on a masonry contract. The Bricklayers Union decided they did not like that contractor, and they started a negative campaign against them, asserting that they were doing bad work or that they mistreated their employees. They weren't paying prevailing wages. They were non-union, et cetera, et cetera. And that's where JJ Construction sued for those statements. Now, there's the Noor-Pennington doctrine that still allows the First Amendment to apply, and there is the different tests that were more substantive. Those aren't supplanted by the UPEPA. What the UPEPA does is it takes those existing legal concepts and puts a procedural framework around them. So you still have all of the legal requirements and elements of the various claims, as well as privileges and other defenses. This now just puts it into a constrained or a faster time period. And as Matt pointed out, and it's something I overlooked, if you have questions as we go along, feel free to either put them in the chat or in the Q&A. And we will try to address them either as we're talking, or we'll also try and at the end address any questions at that point. But the main point that we're talking about now is UPEPA doesn't really change the law. It changes the procedure, and it shifts the leverage and the burdens a little bit.
So there have previously been several attempts to pass anti-SLAPP legislation in Michigan. Most of the early attempts, however, stalled due to debates over scope, particularly regarding whether protections overly shielded government officials and zoning boards. Some of those early versions also would provide defendants with treble damages, would require showings that the action was initiated with the primary purpose of harassing, and some limited the protection to citizens, consumers, and journalists, which we will see differs from the enacted UPEPA. Anti-SLAPP legislation was again introduced in 2024. It passed the House with overwhelming support, but ultimately died in the Senate. It was then introduced in early 2025 with the UPEPA language. It gained massive bipartisan support, and it passed both the House and Senate unanimously and was signed into law by Governor Whitmer on December 23rd, 2025. So for the first time, Michigan has a dedicated standalone anti-SLAPP statute, and it's the uniform version. Now, this means that decisions from other UPEPA states are genuinely persuasive here. So there are three main takeaways from Section 1 of the Act. First, Michigan declares that it's public policy to encourage citizens to vigorously participate in government. Second, the statutory purpose of the Act is to protect citizens from the chilling effect of SLAPP suits. And third, the Act minimizes the damage of those suits by shifting the burden of litigation back onto the party who brought the lawsuit. It does that through expedited review, a stay on discovery, limits on the evidence that the court considers, a defined burden of proof, and the availability of sanctions. So a few key definitions that we're going to briefly touch on and have important implications under the Act are person, which is defined as an individual, estate, trust, partnership, business, or nonprofit entity, governmental unit, or other legal entity. Additionally, governmental unit is defined as a public corporation or government, or governmental subdivision, agency, or instrumentality. So the protected person sweeps in almost any kind of speaker. And this is different from some of the earlier versions of anti-SLAPP legislation that were introduced but not enacted in Michigan. Lastly, goods or services is defined to exclude the creation or promotion of dramatic, literary, musical, political, journalistic, or artistic work, which, as we will discuss further, is an important limit on the commercial speech exclusion to the definition of eligible causes of action under the Act.
In dealing with this eligible cause of action, which for 4 words is going to generate a lot of discussion and activity, and it has in other states as well. But that talks about or is a cause of action asserted after the effective date of the act. Now, this is in the beginning of the act as well as at the end of the act. It's Section 691, 1863, that cause of action asserted after the effective date. So there may be a pending claim that's not covered by UPEPA, but if there's an amendment, potentially that amendment could be subject to UPEPA because it was asserted after the effective date of the act. So essentially, these are looking at the communications by the person in a legislative, executive, judicial, administrative, or other governmental proceeding. So you've got in a proceeding. So sometimes you may hear about the judicial immunity privilege or some of those concepts. So that's one of the communications, or a communication by the person on an issue under consideration or review. So now you've got the commentary, not in the proceeding, but on the issue. And then the larger ones are the exercise of the right of freedom of speech or the press, to assemble, petition the government, the right of association on a matter of public concern. So again, we've got another four-word phrase, matter of public concern, that's going to generate a lot of discussion. And what the courts and what we'll talk about later is there are definitions for matter of public concern that we'll be reviewing and that other courts have reviewed to determine, well, what is this statement that somebody makes that's on a matter of public concern? The other two, whether it's in a proceeding or on an issue under review, those have a fairly good definition. You can conceptualize it. But then when you've got the other speech, assembly, petition, association on a matter of public concern, now it becomes a much larger, less well-defined thing. But again, it applies in Michigan to claims asserted after March 24, 2026, the effective date of the act.
So an otherwise eligible action is not eligible under the Act in two specific situations. First, if it's against someone primarily in the business of selling or leasing goods or services, and the claim arises from a communication about that sale or lease, or the commercial speech exclusion. Second, if it arises from an individual's claim under a specific list of statutes. Essentially, it is all the civil rights statutes. So on the state side, the Elliott-Larsen Civil Rights Act, Persons with Disabilities Civil Rights Act, Whistleblower Protection Act, Workers' Disability Compensation Act, or FOIA. On the federal side, Title VII, Title IX, the ADEA, the ADA, FMLA, and FLSA. So one question moving forward may be whether this carve-out will apply to speech-related claims that are brought in the same case alleging violations of those statutes. Motion mechanics. So after being served with a pleading asserting an eligible cause of action, a party has 60 days to file a motion for expedited relief to dismiss an action or part of an action. The filing of the motion triggers an automatic stay. That stay remains in effect until the court makes a ruling on the motion, plus the time to appeal expires, which is 21 days. If there is a timely appeal, the stay will remain in effect until it is resolved. It is important to note that under the Act, a court is allowed to stay proceedings involving other parties if those issues are tied to the motion. Now, the court may also permit limited discovery if a party shows that it needs specific, otherwise unavailable information to meet its burden. Now, the court will hear the motion within 60 days of filing, but where a party requests and is granted limited discovery, that hearing needs to be within 60 days of that discovery order. Again, unless it is further delayed for good cause. Now, in deciding a special motion, the court may consider the pleadings, the motion, any response or reply, and supporting materials, including affidavits, depositions, admissions, or other documentary evidence. So it's important to note the things to collect and identify prior to filing a special motion.
Now, this is where the new procedure gets a little bit more technical and challenging, trying to understand the shifting back and forth. So it's basically it's a three-phase. So you've got the first phase is applicability. The moving party uh, demonstrates or establishes that the cause of action is an eligible cause of action. So it's eligible for the protections, which means that it was a statement or a communication made under one of those three categories. Then once that applicability is established, then the responding party carries now the burden to demonstrate that one of the exclusions apply. That yes, it may have been a statement in one of those three categories, but one of these other exclusions applies, whether it's commercial speech or artistic or one of the statutory items apply. So, then that's where the respondent now has that burden. But there's another phase that starts talking about the prima facie viability, that now that responding party has to establish a prima facie case on each essential element of the claims. So this is a distinction that we'll go into between the federal and the state in this statute, because at this point now, typically a motion is based on the pleadings. And you've got a moving party moving for dismissal. Here you've got essentially a summary judgment that is occurring on this expedited basis. So if the respondent, who we'll call them the claimant, the person asserting the claim, is not able to establish a prima facie case on each essential element of its claim, that claim will be dismissed. Alternatively, or in addition, that moving party can establish that the respondent, and this is where it gets really weird because it applies to claims and counterclaims. So the responding party did not state a viable cause of action or failed to state a claim. So basically a C8, or there's no genuine issue of material fact, a C10. So if either one of those, so you've got three ways that the claim can get dismissed, is that if the respondent doesn't establish a prima facie case on each element, failed to state a claim upon which relief can be granted, or there's no genuine issue of material fact. And again, we're talking at an expedited hearing stage. So the time period for addressing this is very compressed. As Anna Claire mentioned, you've got 60 days from when you're served. Then unless there's discovery, the hearing is within 60 days, and then the court has 60 days to rule. So you may be at a decision point within 120 to 180 days from when the complaint was served or the claim was served that may be subject to UPEPA.
Under the Act, if the motion is denied in whole or in part, the moving party has an appeal as of right. And as I previously mentioned, it must be filed within 21 days of the order. And it is important to note that the statutory language specifies that the right is given to the moving party, not to the responding party. Additionally, under Section 10 of the Act, fee shifting is mandatory. If the moving party prevails on the motion, the court must award it court costs, reasonable attorney's fees, and litigation expenses related to the motion. However, it runs the other way as well. If the responding party prevails, and the court finds the motion was frivolous or filed solely to delay, the responding party gets its fees. Additionally, the Act instructs courts to construe it broadly to protect speech, press, assembly, petition, and association rights under both constitutions. This is something to note as it can be helpful in early UPEPA arguments and motions.
Now, since we in Michigan have a new act that is roughly about slightly over 2 months old, or roughly 2 months old, we don't have a huge body of law developed around it. So sometimes we have to look to some of the other states that have similar acts. Now, in California, in DC, and Texas, and Massachusetts, some of those are not UPEPA. They, like the California law predates UPEPA, as does Massachusetts. So when you go look to some of those other states for guidance, you need to be a little careful because they may have different language in there in a different purpose. Like California tends to be very broad, especially on treatment of public issues and participating in governmental actions. Texas has a more narrow commercial dispute carve out. So that's another one where you need to be, when you're borrowing from another state or looking at the laws of another state, you can see language that looks to be very positive, but then as you compare it to the language of our UPEPA, you'll see the distinctions that may no longer make that language from another state applicable or even helpful. So that's going to come up fairly frequently as we work our way through UPEPA and its application in the defense of defamation or speech-related claims.
So as of early 2026, 15 other states have also enacted UPEPA, a few of which include Delaware, Iowa, Kentucky, Maine, Ohio, Pennsylvania, Utah, and Washington. Interpretations and applications from the other UPEPA jurisdictions can provide persuasive authority for early Michigan motions and provide some helpful points to consider. For example, in Tesoro, a Delaware court recently denied the application of UPEPA in a commercial setting for an alleged repudiation, not a protected communication. The court pointed out the distinction between speech that provides the basis for liability and speech that provides evidence of liability. So a communication that serves merely as evidence of a complained wrong is not itself the injury-producing conduct.
And just to expand on that a little bit, what Tesoro was asserting was there was a series of letters that had been exchanged, and some of the letters made statements indicating that an Aniptis Bio was not going to perform its contract. So there was speech, and according to Aniptis Bio, the speech was of a matter of public concern. The issue was, from the court's analysis, those statements weren't defamatory. They weren't actionable in and of themselves. They were indicators of an actual or potential breach of contract. So there's going to be this interesting balancing when they're analyzing speech as to whether or not the claim arises out of the speech itself, or the speech is merely an indicator of the behavior leading to liability. So that's especially the overlap to the commercial things when you've got a contract issue that they're also asserting some type of a tort claim with it. These types of issues are going to get interesting.
Another point was made by the Washington Supreme Court in Thurman v. Cowles. The court held that UPEPA does not apply to a claim originally filed in a complaint prior to the effective date of the act, even though it remained as part of the subsequent amended complaint. Whereas a claim that was added in addition in the amended complaint received UPEPA analysis. In Thurman, the Court of Appeals also held that an amended pleading falls under other pleading for the purpose of the 60-day filing deadline provision. It also clarified that fee recovery is mandatory for a party partially prevailing on a special motion. Also of note from that case is that the Court of Appeals looked at the specific provisions in UPEPA for narrow discovery and the grant of an immediate appeal and determined that it conflicted with the court rules. They said that until the Supreme Court adopts a rule allowing direct appeal, such orders should be reviewed in the normal discretionary review standard. Of note, the Michigan Supreme Court has proposed an addition and amendment to the court rules to provide the process for special motions under UPEPA and to clarify the availability and applicability of the stay during an appeal as contemplated in the Act. Now, there are 2 points to bring up from Davenport Extreme Pools and Spas. First, the Kentucky Court of Appeals held that UPEPA is purely procedural, as it creates an expedited dismissal motion that mirrored existing standards. This will be brought up again as we look at federal court treatment of UPEPA. And secondly, the court, in analyzing whether the plaintiff was able to establish a prima facie case for tortious interference, highlighted the fact that the plaintiff failed to use available limited discovery under UPEPA. This is important to remember for a responding party to a special motion and for the moving party for appeal issues, as Michigan's UPEPA also provides for limited discovery.
And just another point on Davenport, that was a consumer complaint. There were 2 purchasers of Davenport pools that were complaining that Davenport had not performed the contract. They were communicating between each other and they were communicating with others that resulted in some sales not going forward. And that was the gist of Davenport going forward with its action against Melfleur and the other. And when the defendants raised this UPEPA under Kentucky law, they were trying to argue again, well, it was commercial speech. No, it pretty much applied. But then the question became, is it retroactive and all of that? And that's where even the Kentucky court said, this is a procedural act. It doesn't change the law. It just creates that framework. But one of the other interesting points at that case was with regard to attorney's fees. When the responding or the moving party was successful in getting the matter dismissed, the court awarded attorney's fees that included all of the activities that the moving party's attorney had participated in. So it was a little bit broader than some of the other rulings. So some of these cases are instructive, but can also be a little dangerous because not every case is lining up with consistent interpretations of the same language.
The Supreme Court of Utah also clarifies the burden shifting function of UPEPA in McKee v. Krause. In that case, the court explained that although the plaintiff had made a prima facie showing, the trial court had wrongly put the burden of disproving privilege on the defendant. Under UPEPA, the plaintiff must show a prima facie case that the statements weren't privileged. Lastly, a plaintiff can't amend a complaint to avoid dismissal by adding specific carve-outs. The Washington Circuit Court of Appeals explained this point in Ja v. Khan. In this case, the plaintiff attempted to amend his complaint to add a specific carve-out to avoid dismissal under UPEPA. The court held that this was improper and that during a stay, a court can only hear motions unrelated to the UPEPA motion or emergency injunctions.
Now, when we get into the interplay of the federal court and state court with UPEPA, because UPEPA is a Michigan statute, and the courts that have been confronted with it, usually on a diversity action. So part of the question is it substantive or procedural? And by and large, the courts have found that it is procedural. There are exceptions with the state of Maine, the federal court in Maine, and the Ninth Circuit out west has not found it to be procedural and not preempted by federal law. So what you run into, and it became more apparent with the recent decision of Burke versus Choi out of the United States Supreme Court, where that struck down a medical malpractice affidavit of merit statute in federal court, saying that was a procedural matter and it conflicted with federal procedure, therefore it wasn't going to be applied. There are more states, when they look at UPEPA and they look at the conflict between the UPEPA procedure and the federal rules of civil procedure. And one of the interesting cases that's talked about it is saying, well, under 12b-6, under the federal rules, it's a pleading standard. The pleadings are reviewed. Does the plaintiff adequately plead the claim? With UPEPA, is the plaintiff actually able to provide a prima facie case for each essential element of the claim at this expedited hearing process? So that's where some of the courts the federal courts have looked at it and said, yeah, there's a conflict there. And in federal practice, the federal rules then will trump the state rules. Now, interestingly enough, there is a case that was issued out of the DC Circuit, Abbas versus Foreign Policy Group, that was back in 2015, that was authored by now Justice Kavanaugh, but he wrote the opinion when he was on the DC Circuit saying the conflict is irreconcilable. So their SLAPP, anti-SLAPP law in the District of Columbia was not applicable in the federal court. So we don't have explicit direction from the Sixth Circuit yet, but Kentucky and Tennessee appear to be of the same mind, that the Kentucky UPEPA and the Tennessee version both conflict with the federal rules. Those decisions were before Burke versus Choi, and it's possible that the Burke versus Choi standard in dealing with the preemption and the conflicts between the state and the federal rules may prevent the application of UPEPA, Michigan UPEPA, in the Michigan federal courts. Again, may. There may be other arguments that can be made to get around and avoid those items, but just to be aware that there are courts out there that have found these conflicts between the federal procedures and the state statute that they have said that the UPEPA Act will not apply in the federal court. So it's be aware, be warned that if you're considering removing a state court action to federal court, and if you have an actual or potential UPEPA issue, whether or not you are in better stead staying in state court or proceeding with the removal.
So a few early Michigan UPEPA developments: Cotton v. Lyons, a defamation action filed in Wayne County Circuit Court by Grosse Pointe School Board member Sean Cotton against Kurt Lyons over online statements comparing Cotton's political views to the KKK, has been covered in the media as an early Michigan UPEPA test case. The defendant filed a UPEPA special motion, and a hearing is expected in July of 2026. This may be one to keep your eye on. Additionally, the comment period to the proposed addition and amendment to the Michigan Court rules that I mentioned previously closes in August. So that will also be something to watch out for, particularly in the process and appeal of any special motions under UPEPA.
Now, what's going to make this bill and this act interesting is, like I said, some of the phrases that are in here, like the matter of public concern. Now, the matter of public concern, even under the commentary of UPEPA, looks to the United States Supreme Court, and in particular, Snyder decision from 562 U.S. 443, 2011 decision that says that a matter of public concern, when it can be fairly considered as relating to any matter of political, social, or other concern to the community, or when it is a subject of legitimate news interest, that is a subject of general interest and of value and concern to the public. Now, they also look at it in context, and you examine the content, form, and context of that speech as revealed by the whole record. So a matter of public concern has been found relative to what some people asserted were private issues. A teacher in a school who was abusive or alleged to be abusive of students. There was also some communications about some students being abusive of other students. And some of the arguments were, well, those were private matters. You know, those really weren't matters of public concern, but the court looked at them in the context and saying, well, you know, when it's a matter of political, social, or other concern to the community. So even though it may have been a private matter as between a family and a school, family and a teacher, they viewed the allegations or the statements, because we're talking about the communications, that those communications were sufficiently of a matter of public concern that UPEPA applied to there. So then it would have to go through the three-stage analysis to determine whether or not the claim would survive. Then when we get to the goods and services, it's going to be interesting because there was there are some commentary in the act itself, or in the comments from the Uniform Act Committee. And when they say that, like an example, they say if a mattress store is sued for false statements made in its advertising of mattresses, whether by an aggrieved consumer or a competitor, the mattress store would not be able to avail itself of the act. So there you've got the commercial speech, the advertising, whether in statements like that are not going to fall under the act. But if the same mattress store were sued for tortious interference for organizing a petition campaign to oppose the building of a new school, its activity is not related to the sale or lease of goods, and it could use the act for protection of its First Amendment statements and conduct. So it's really not a blanket statement that if it involves a commercial entity, it will be commercial speech. So it all depends on, is that in furtherance of the business? And similarly, the commercial speech does not apply to the creation, dissemination, exhibition, or advertisement of a dramatic, literary, musical, political, journalistic, or artistic work. So those works are not considered goods or services. So those types of things when you look at a potential situation and say, yes, was speech involved? Okay, at a very high level, that's a possibility that you look at it to start drilling down to determine, okay, is it a matter of public concern? Is it something that is commercial speech or expressive, or does it fall under one of the statutes? So there's going to be a lot of discussion. There are several cases already. There was some the PeopleWorks case, or People Connect, Boshears filed an action over People Connect, who was putting out a directory of different class yearbooks, and Boshears objected to being included in there. And People Connect attempted to use UPEPA, and they said, it's commercial speech, so it doesn't really apply there. That isn't a defense to that type of a claim. So each one will have to be evaluated on its own. And particularly, you start looking at employment cases where they do have those statutory exemptions. If there are claims outside of those statutory exemptions, how does that play in? We'll have to resolve that issue with the federal court application of UPEPA in light of Burke versus Choi. And then when it talks about the fees, the cases are, and the statute itself says, a voluntary dismissal does not deprive the moving party of its ability to go forward with the hearing and obtain dismissal and obtain attorney's fees. So that, there are some courts that have raised a question about that. But then there's also the question about, well, what if you don't get rid of all of the claims? So some of the claims maybe survive. Okay, is there a partial award of attorney's fees? Because the attorney fee provision in UPEPA is mandatory. It is a shall award. So those are some of the questions. I mean, there's obviously going to be several more questions, but those are some of the questions that we're probably going to be confronting fairly soon, on what this act entails, what it allows, and how people will be able to use the act in their defense cases. Yeah, there's there are some people out there that have raised these notions that anytime I criticize somebody, I get sued. And there's this meme basically saying your feedback is now a lawsuit. If you're looking at something like this, like you've got a consumer who leaves negative feedback against a business, would that now be subject to UPEPA? Potentially, depending on what the consumer says and how they say it. Then if they were to get sued and that consumer then asserted or demanded the expedited review within the 60 days, and they performed the analysis to evaluate whether it was an eligible communication, and then whether the any exception applied, and then did the plaintiff were they able to establish a prima facie case, or did they fail to state a claim upon which relief can be granted, or fail to create a genuine issue of material fact? So you start to see how these things are going to come about. And there's already people out there that are kind of beating the drum, sort of, in a manner of speech.
So there are four main takeaways we want to leave you with today. First, the 60-day deadline. UPEPA is not a defense to plead in an answer and just forget about. The moment a covered claim is served, the clock to file a motion for expedited relief starts. So when you receive a pleading, immediately check it for UPEPA applicability and calendar that 60-day deadline. Second, filing a motion for expedited relief has two very concrete consequences: the discovery stay and the fee shifting provision. It's important to remember that the stay can be applied to other actions as well. Additionally, that fee shifting provision goes both ways. Third, keep in mind that the statute is new. Early appellate decisions will be shaped how initial UPEPA arguments are made. So stay up to date on how Michigan practitioners are using, arguing, and prevailing under the Act. Fourth, strategy matters more than usual. Forum selection, pleading discipline, and special attention to persuasive authority coming out of states that have also enacted UPEPA is imperative for initial UPEPA motions in Michigan.
A couple other um, examples that I think are interesting when it comes to commercial speech, because that's where one of the areas that is likely to come. Because when it comes to consumers, odds are they may be able to assert an eligible communication. And again, the eligible communication is the first tier. It's the second tier when the burden shifts to the respondent to demonstrate that some exception applied. So let's take a widget manufacturer that hires a marketing firm. And then that marketing firm creates fake online reviews and social media posts claiming that companies B widgets are causing fires, are cheaply made, they're not adequate. They're not of fair average quality. Then company B finds out that company A was behind it. Company B sues company A for defamation, tortious interference, unfair business practices and things like that. Then company A then says, well, I made a claim or made a statement, so it's an eligible communication. But now company B is going to say, yeah, but you did it in furtherance of your business. That was, you know, that was a competitive statement. That was commercial speech. That's not protected by UPEPA. So you start to see that maybe, all right, some of these unfair competition claims and things like that may not be may not get UPEPA depending on what the statement is. And again, like a financial services firm is putting statements out there about their rates of return and other things that they may be able to provide to a customer. Um, that's typically not likely to fall under UPEPA as the commercial speech. So again, we're in sort of uncharted territory in trying to determine what speech is applies and how it applies. And sometimes the analytical framework of the statute can get you twisted up a little bit because now you're accelerating things and then you've got these burdens that are shifting back and forth, and they're not typically the way that a normal case would view the burdens, particularly when you bring in and you accelerate that prima facie showing at that hearing stage, which the hearing could be as quickly as 60 days after the accelerated process is invoked. So, it's going to put large onus on the person asserting the claim, whether it's the plaintiff or a counter plaintiff asserting that type of a claim, to be prepared or have a strategy ready to engage in limited discovery in order to establish that prima facie claim. So that's part of the interesting thing that we're going to be dealing with from both a definitional standpoint and a practical application standpoint. Because one thing that's interesting in the statute, that it also says that the court shall rule within 60 days of the hearing. So that's another interesting time frame there. So you've got an outside window of when the court shall issue a ruling on the application of UPEPA. So I'm just looking to see. No, Anna Claire, is there any other topics that you wanted to go into deeper dive on?
I think that was it, but we wanted to see if anyone had any questions.
Seeing anything pop up in the chat or the Q&A at this point. So I think we will be watching to see what happens. We know there is the cotton case. There's also word that there are a few other actions in various parts of the state that may implicate the application of UPEPA, but it just went into effect March 24. So there are some claims that may have been filed since then, but the 60 days from the date of service hasn't passed yet. So the implication or invocation of UPEPA may not have occurred. So I think thanks, Rick. And if anybody, hopefully somebody has an experience later on that they'll be able to share, and I'm sure everyone will be more than thrilled to hear about it.
All right, looks like we're not getting any questions. So thank you very much, John and Anna Claire, for your presentation. Everyone who's attending, this event is recorded and will be going up on the MDTC YouTube channel. So go ahead and check it out there if you want to review any parts of it. Thank you all.
All right.
Thank
Thank you
you.
very much. Bye.